pass the lease. All right, thank you for coming, and as you find your seat, very happy that you're here, whether you're from this faith community, other faith communities, or from Evanston more generally. I think it's really important that we come to understand a little bit more about our environment, our city, how we can form connections and collaborations. And so to that end, we are going to be hearing from Liza Roberson-Young, and she is the Chief Legislative Policy Advisor for the City of Evanston, where she assists the City Council and the Mayor's Office with developing and drafting legislation. And previously, she served as Senior Supervising Policy Counsel for the ACLU of Illinois, where she worked on a broad range of civil liberties issues, including reproductive rights, LGBTQ+ issues, the First Amendment, and data privacy and surveillance. And she has much more that I could read, but what we're here to do is sort of understand the landscape, and then we are going to toss it to you if you have questions about stuff like what has changed with the sensitive locations memo, for instance, being rescinded for public buildings. What does that look like? If you have questions about the City of Evanston's Welcoming City resolution and its recent update to make it stronger, you can ask those questions. I know Liza's very proud of that work, right? And I think we're proud of that work too in the city. And so if you want to ask questions about that, that's okay. This is not a know your rights training. This is more on the scale of sort of policy, trying to understand that. And then if you have questions or if you want to think about ways that faith communities or neighborhoods or whatever interest you represent here can connect with the city to form partnerships, I think that is a very good use of your time and our time here today. And so without further ado, I welcome to the pulpit Liza Roberson-Young.
Hi, everyone. Thank you so much, Reverend Woolf and Lake Street Church and all of you for inviting me here today. I know we're living in pretty scary and uncertain times, and I think coming together in community like this, having conversations like this, is one of the most powerful tools we have to fight back, so I'm really thrilled to be here. So as Reverend Woolf mentioned, I think the first thing I'm going to talk about is our Welcoming City Ordinance. And as you may have seen, we recently enacted some updates to strengthen the Welcoming City Ordinance in anticipation of kind of the onslaught that we've seen over the last couple of weeks. So just to give you a little background, Evanston first enacted its Welcoming City Ordinance in 2016 with an update in 2017 to bring the ordinance in line with state law. And that ordinance provided that city officials will not participate in federal civil immigration enforcement, and that city officials, staff, and police will not inquire about a person's immigration status. So I think that was a great law when we enacted it in 2017. It has some really important protections in it. But since 2017, the law in this area has evolved. The state law has been amended to close some loopholes and strengthen its protections. Other municipalities, including Chicago, have updated their welcoming city policies. And then we've also seen some emerging issues in immigration enforcement that the 2017 ordinance did not fully contemplate, especially around the federal government's use of local government data to target people based on immigration or citizenship status. So for all these reasons, City Council voted on January 13th to update the Welcoming City Ordinance to ensure that Evanston has the most robust safeguards in place to protect as much as we possibly can against the overreaches in immigration enforcement that we're seeing. So to get a little bit more specific about what the new ordinance does, it retains all the protections I just talked about in the original Welcoming City Ordinance, most significantly the prohibition on using any city resources to enforce federal civil immigration law. But it adds some new protections and closes some loopholes. So I think one of the most critical things the new ordinance does is that it ensures that any data collected by the city will not be used for immigration enforcement. It says that the city will not share any city database or data sharing platform with immigration officials, with any other federal agency, if the reason they want the data is to enforce civil immigration law. And this is, I think, the really important part. It says we will not share data with any third parties, like private data brokers who resell information that they obtain from local government, unless the third party certifies that the information we give them won't be used for immigration purposes. And this is really important because ICE routinely uses data obtained from local government or from private companies to surveil immigrants and target enforcement operations. They operate a pretty massive surveillance program that depends in large part on obtaining data directly from state or local government or from seemingly neutral third-party data brokers who collect government data and then in turn resell or give the data to ICE. So I think one really kind of alarming aspect or example of how they use this information is that they track data related to utility hookups, so they can track when people have moved to a different address, and generally exploit data that people give to state and local agencies and institutions in exchange for essential services without knowing that their data might be shared. So I think this is a really important provision of our new law. We are the first jurisdiction in the state to enact this kind of data protection, and possibly at least one of the first in the nation, if not the first in the nation. A second really important thing that the new welcoming city ordinance does is it closes some loopholes that formerly permitted the city to participate in civil immigration enforcement. So this includes some exceptions that allowed cooperation if someone was listed in a gang database, if someone had been charged with but not convicted of a crime, or if they had an old unrelated felony conviction. So nothing related to their current status, but the fact that they had been targeted previously. So this is important, I think, because as I'm sure many of you know, gang databases are notoriously discriminatory. The fact that someone has been charged with a crime does not mean they committed a crime, and we don't think those should be bases for the city cooperating with civil immigration enforcement. The city will still continue to comply as it is required by law if it is presented with a valid criminal warrant that comports with constitutional requirements of probable cause, but short of providing a warrant signed by a federal judge, the city will not cooperate in those instances. A third thing that the ordinance does is it ensures that the city will not participate in civil immigration enforcement with any immigration agent, including not only ICE agents, which is already prohibited under the original ordinance, but also agents from other federal agencies that might be deputized to enforce immigration law, and also anyone managing an immigration detention facility, including facilities run by private prison corporations. And this was really important because our previous ordinance arguably could have been interpreted to apply only to ICE agents, and therefore potentially had this loophole that would allow city participation in immigration enforcement conducted by other federal officials, or I think really crucially by personnel at detention facilities who are often private contractors. And we know there's been a lot of media reporting that the new administration is already planning to significantly expand immigration detention facilities operated by private prison corporations. And so we're really thrilled that the new ordinance ensures that we will not share information with those kinds of entities as well. A fourth thing that the new ordinance does is it codifies some of our current practices so they have the force of law. We think these are best practices and we want to ensure they're continued going forward. So this includes requiring the city to work with immigrants who report crimes to help them secure particular forms of visa relief that are available to crime victims. You may have heard of U or T visas. These are visas that you're eligible for if you report a crime or work with law enforcement to investigate or prosecute a crime, and they're intended to encourage people who may be undocumented to come forward by mitigating any adverse immigration consequences they might otherwise fear in contacting law enforcement. However, to apply for these visas, the applicant has to submit paperwork signed by law enforcement, and sometimes that's difficult for them to get. So this provision just says if we get a request for that kind of paperwork, we will assist them in any way we can. Other parts of our current practice that this codifies is prohibiting the city from entering into an agreement with the federal government that allows local officials to enforce federal immigration law, and requiring that when the Evanston Police Department gets a request from ICE, that a supervising officer, rather than someone who might not be trained, makes the decision about whether a request from ICE is a civil or criminal enforcement matter, and therefore whether it's the type of request the city would comply with or not. And then the last thing it does is it says that the city will offer public resources related to immigration, including requiring the city to develop policies for our public buildings that limit immigration enforcement operations on their premises to the greatest extent permitted by law, and encouraging the city to take steps to offer immigration resource information through 311. So that's kind of a summary of what our new ordinance does. I want to also say a quick word about litigation challenging these kinds of laws. You may have seen that I think just in the last hour, the Department of Justice filed a lawsuit against the state of Illinois, the city of Chicago, and Cook County, challenging their sanctuary laws. In general, courts have upheld laws like ours. This is an issue that the city litigated in the first Trump administration, when the Department of Justice tried to deny grants for community policing and public safety efforts to us because of our welcoming city ordinance. And in response, we, along with many other cities and many other states, sued DOJ, arguing that their attempt to withhold the funding was coercive and unconstitutional. And the kind of legal argument there is that under the 10th Amendment, the federal government can't say what laws states and local government prosecute, and can't force states and local government to enforce federal law. And this is something called the anti-commandeering doctrine. And so those arguments were generally successful, and courts generally held that the Department of Justice could not withhold funding just because of these laws, and could not coerce states into enforcing federal immigration law. The lawsuit filed today, I don't want to get too ahead of my skis here because I have just skimmed it very briefly. It's a little bit different. It argues that under the Supremacy Clause of the United States Constitution, states cannot enact laws like our welcoming city ordinance. So it'll be interesting to see how that variation on the arguments plays out. But the previous lawsuits challenging these kinds of laws, cities like Evanston have generally prevailed. So unless anyone wants to talk about the welcoming city ordinance or has any questions, I can move on to the next issue I was going to talk about. So the next thing that I wanted to talk with you about is the ICE's sensitive locations policy, which I'm sure many of you know more about than I do, but just as background, for a long time under this policy memorandum that was first issued in 2011, it was ICE's official policy that it would not engage in enforcement actions at sensitive locations like schools and places of worship unless exigent circumstances exist, other law enforcement actions led officers to a sensitive location, or they had obtained a prior approval from someone higher up at ICE. And this policy actually stayed in effect during the first Trump administration. There was a lot of reporting that they were considering rescinding it, but they never got around to it. So it has been in effect since 2011, including throughout President Trump's entire first term. However, one of his first actions in the last couple of weeks has been to follow through on the earlier threat to rescind the policy, so the policy has now been withdrawn. And what this means is that ICE can now, without any limitations, conduct arrests in places where vulnerable people, including undocumented folks, are seeking essential services or gathering to worship. So this is disheartening, but we still have some ways to fight back against this. All people in the United States still have basic constitutional rights regardless of immigration status. The Fourth Amendment protects all people from unreasonable searches and seizures regardless of immigration status, and the Fifth Amendment says that you have the right to remain silent when confronted by law enforcement. So people still have those rights. Those have not been changed by the rescission of this policy. And then we also have our state law that prohibits law enforcement from cooperating with civil immigration operations, and our local law that we just discussed. It'll also be interesting to see as we go forward whether there's a legal challenge to the withdrawal of the sensitive locations policy and kind of how that plays out. So I guess there are two things I wanted to convey about this. We're not powerless, and the legal landscape is changing very, very quickly. So a little bit more kind of guidance on how to deal with ICE showing up. I'm not someone who's trained to do Know Your Rights trainings, and I know you're working with the Illinois Coalition for Immigrant and Refugee Relief and other organizations on setting up those kinds of trainings. Those are the real experts, but I can share a few thoughts. Again, I just want to underscore the law in this area is changing constantly and rapidly. It's hard to stay on top of what is happening. And groups like ICER, the National Immigration Justice Center, the National Immigration Law Center, the ACLU, are all really engaged on this work on a day-to-day basis on the ground. They're constantly updating their websites, their legal advice, their Know Your Rights trainings to stay on top of new developments. And that's where I get my information about how things are changing. And I think if you're looking for information about where the law is going and what your rights are, those organizations are all doing incredible work. Second, if ICE agents show up with an administrative warrant or with no warrant at all, you do not have to comply. And I think it's important to discuss the difference between an administrative warrant and a judicial warrant. So an administrative warrant is a warrant signed by an ICE official. No judge has reviewed it. There hasn't been any finding of probable cause. It's just a piece of paper signed by an ICE official. And those are not enforceable. They can't compel you to comply with those. And a judicial warrant is a warrant that ICE has taken to a judge. The judge has made a finding that there's probable cause that supports the warrant, and the judge has signed it. So if you're presented with a warrant signed by an administrative official, you do not have to comply. If you are presented with a warrant signed by a judge, those are enforceable. Third, in general, ICE agents may enter public spaces that are open to the general public, but they can't offer private areas like offices or places that the general public can't just wander into unless they have a judicial warrant authorizing that entry. So for places of worship, I think it's helpful to think through what areas are public, what areas are private, really clearly share that information. I know you have some great signs up already that help convey this information. I think it's also useful to think about designating a person who will be the point of contact if ICE shows up and ensuring that that person is really trained on knowing the difference between an administrative warrant and a judicial warrant. So happy to take any questions about sensitive locations.
Yes, I came from St. John's Parish, St. John's Parish, and some of our ushers and rapid response teams and so forth have been talking about two things. One, has it very recently been changed, the admin warrant versus the judicial? Because one thing we're hearing is now neither one manner, they can still come.
No, that has not changed. The thing that has changed, I'm sorry. Oh, sorry.
Yeah, my question was that we've heard recently that even the admin, whether the ICE has either the admin or the judicial, it doesn't matter. They said because of the executive, what is it called? Executive order. Those are kaput.
No, that has not changed. You still do not have to comply with an administrative warrant. You still do have to comply with the judicial warrant. Trump cannot, through executive order, undermine the Constitution.
So if an ICE agent enters a church and we ask for a warrant and they say nope, and they come in anyway, what can we do beyond recording?
In that case, I would recommend that you contact the city and the Evanston Police Department.
Okay, in the moment though, they can detain a person if they have their name, right?
I don't want to get too into specifics about how that would operate, but I think calling the Evanston Police Department so that they could navigate the situation and determine whether ICE has the proper paperwork or whether they're conducting an illegal operation would be the right move.
Thank you. Do you know what's been shared with the Evanston school districts about sensitive places and their obligations? I'm asking because I have a fourth grader in an Evanston school, and the kids are talking about this already in fourth grade with concern about their friends or families or whatever. So I'm just curious what you know, what's been shared with the district.
I don't know specifically off the top of my head. I know that they have issued some kind of guidance, I think on their website, kind of explaining what their policy is and explaining that they will not let ICE into the schools. But I don't know offhand what exactly the parameters of that guidance are, but I would recommend checking their websites.
One of our thoughts here, one of my thoughts anyway, when ICE shows up and the worship program is in process, to simply ask them to respect the service and keep them out of the narthex. We're not preventing them from coming in, but we want to keep the service sacred, if you would.
Yeah, I mean, you could certainly ask them to respect, but they would not be required to if they had a judicial warrant.
That's what I thought.
And that's that I think is the real outcome of the rescission of the sensitive locations policy that they used to avoid doing immigration enforcement in places of worship, and they now no longer have that policy.
Yeah. Thank you.
Yes, I have a question about the Know Your Rights, City of Evanston Know Your Rights pamphlet that was handed out when we came in. And my question about that is, since we're not really addressing that specifically today, will there be conducted by the city Know Your Rights things for not only the immigrants, but for those of us who want to support the immigrants about what our rights are and what we can and cannot do to support them?
Yes, on January 20th, which was Inauguration Day, the city hosted a Know Your Rights training at the Civic Center that is available on the city's YouTube page. I do have to caution you that even though that was extraordinarily recent, it is already slightly out of date because this was before the sensitive locations policy was rescinded and before the slew of executive orders we've seen. But I think we tried to flag areas that we thought might be changing during that training, and so I would recommend that as a resource. Organizations like the Illinois Coalition for Immigrant and Refugee Rights have Know Your Rights information on their websites. We are working on doing another Know Your Rights training. I don't have the exact details. We're figuring out date and location, but that will be coming out soon. And other organizations, like faith organizations, are also conducting Know Your Rights trainings.
I also, excuse me, I also have a question about the recent change to the Venezuela protections for those who are going through the asylum process. I know that there's a number of those people who settled in the Chicago area and are going through legal process, or were going through legal processes for asylum. Do you have any insight to that or guidance? I don't know that much about it actually, and like what the full process is, and like are some of them still moving forward? Are all of them completely axed if they've started the process, et cetera?
I think there's a lot of confusion on that point right now, and so I don't want to. I don't want to say anything that might be wrong. I think part of the purpose of what we're seeing right now is to generate fear and confusion. I know that there's been an executive order that tries to shut down asylum at the border. I'm not sure what ramifications that has for people who are already here and engaged in the asylum process.
A couple of weeks ago, a home in Elgin, I believe it was entered without, ICE entered without a warrant. As a matter of fact, battering the door down to get in, and they did not have any kind of warrant. Who enforces that crime?
That's a great question. Again, if you find yourself in that situation, I would recommend calling the Evanston Police Department. I know the Illinois Attorney General's office also does some enforcement in this area, and I would consider reporting it to them. I don't know that they would be able to help right in the moment. I think if you want someone there to help you as it's happening, contacting the Evanston Police Department would be your best call.
I was hoping you could go again through the changes. You talked pretty fast, and I missed a couple of them. Take a deep breath, slow down. Okay, the first one was the no data sharing, the data protection, and the second one was a bit similar. Could you go over that one again?
Yes, my apologies for talking too quickly. I will try to slow down. So yes, you're absolutely correct. The first change that I talked about was the data protection provision. The second provision that I talked about was closing some loopholes in our previous ordinance. The 2017 ordinance had these exceptions that allowed the city to participate in civil immigration enforcement operations under a few different circumstances. And one of those was if someone was listed in a gang database. One of them was if someone had been charged with but not convicted of a crime, so there was no proof that they had committed the crime. Or if someone had an old, unrelated criminal conviction that had nothing to do with their current circumstances, where they had served their time, and it's unrelated to whatever's happening now. So the new ordinance removes all of those exceptions, closes those loopholes, and ensures that the city will not participate in civil immigration enforcement under those circumstances. The city still is required to work with ICE if they present a valid, current criminal warrant that complies with standards of probable cause. No problem.
The recent provision that you just mentioned about individuals who have simply been accused of crimes, I think there was federal legislation within the past couple weeks, the so-called Laken-Riley Act, which seems to directly contradict that. And I'm wondering, is that also going to be a subject of lawsuits against the city?
That is a great question, and it is hard to predict what Trump and his Department of Justice will do. It was not, a violation of the Laken-Riley Act was not among the grounds asserted in the lawsuit filed today, I don't believe. How that would interplay with local or state protections like the ones we've been talking about, I think is something the courts would have to sort out.
I have a very broad general question, but I'm curious about, federal law versus state law versus local law. It seems like it would be, opening anarchy if every community could just come up with their own laws. I thought federal laws covered the United States. So can you kind of go over that?
Yeah, that's a fantastic question. As a general matter, you're correct. Federal law applies to everywhere in the United States. State law applies to everywhere in Illinois. Local law applies to everyone in Evanston. But it is not always the case that a law enacted at a broader level supersedes a law enacted at a more local level. And this is because of principles of federalism and the 10th Amendment, which reserves powers to the state. And so there are constitutional limitations on the extent to which federal law can compel states to do certain things. There are times when federal law can compel states to do things. The kind of classic example is Congress can condition federal highway funding based on states having a drinking age of 21 or over. And that's permissible because the funding condition is related to the requirement. But courts have held that trying to withhold funds from sanctuary jurisdictions, that is not related to the underlying law, and the federal government has no authority to compel state police power to be used to enforce federal law. I hope that helps. It's very complicated.
Excuse me. Earlier in your presentation, you talked about public spaces. So, for example, in the church, if part of the sanctuary was the public space, then they could come in there. But in private offices, Reverend Woolf's office, for example, not so much. So, what about private homes? My interest is if, for example, I had a family staying in my home that I was sheltering in some fashion or renting to or what have you, and somebody came to that home. Without that judicial warrant, they would not be permitted to enter.
That's correct. For public spaces, if it's a place anyone from the public can come in, ICE agents can too. If it's a private home, they have to have a warrant, and they have to have a judicial warrant.
So, just going back to the previous question, the federal versus state versus local law question, if I'm understanding you correctly, you're saying that the federal laws apply, despite the state or local law being different, but we don't have an obligation to enforce them with our state or locally funded resources. Is that what you're saying?
That's correct.
Okay.
The federal government can still come to Illinois and enforce federal civil immigration law if federal officials are the ones doing it, but we have both a local and a state policy that we will not use state or local resources to enforce federal civil immigration law.
Hi. The gentleman who spoke about coming into a home, if the warrant has one person's name on it, can anyone else in the family also be arrested?
I'm sorry, can you repeat the question?
Yeah. So if, or it applies to a church too, if there's a judicial warrant with one person's name on it, can the federal agencies, ICE, also arrest members of the family who are not named, or anyone else there not named?
Yeah, I think that's a great question, and I think that's a question for a Know Your Rights training. It's a little farther afield than I feel qualified to opine on right now.
So, yeah, I want to go back to if somebody comes in with a judicial warrant, if ICE shows up on Sunday morning with a judicial warrant, could I still hide somebody in my office? And would that judicial warrant enable them to come into my office?
If someone is in a private space and ICE does not have a judicial warrant, they're not entitled to enter that private space. There is a federal statute that prohibits harboring an undocumented person, and so that comes into play. Like if someone is providing false documentation to someone, or sometimes if you're helping them participate in a sham marriage or something like that. And this, I think, is another question for the Know Your Rights training, the specific contours of this doctrine. So if you were deliberately hiding someone from ICE, I would ask at a Know Your Rights training how to navigate that situation. But just because they're allowed in a public space does not mean they can go enter a private space without having a judicial warrant.
I'm not sure this is the right venue either for this question, but the phrase that you keep using is federal civil immigration law, which implies there's federal criminal immigration law, and I'm not clear what the difference is.
Yeah, so that distinction is at the root of the administrative warrant and judicial warrant distinctions. The administrative warrant is a civil immigration offense, so it's like, I don't know, getting a parking fine or something. It's not something that you can arrest someone for. a criminal judicial warrant is enforceable and can be used to enforce a crime. So there would be some evidence that a crime had been committed.
But simply like being here as an undocumented person, is that regarded as a civil violation or a criminal violation?
I believe that is generally a civil violation, but it may depend on very fact-specific things about the conditions of your entry, what kind of relief you might be entitled to, a bunch of other things, and that, again, would be, I think, a great question for a Know Your Rights training.
This might be another question for Know Your Rights training. If a person lives in a building where they have to, a person like ICE would have to buzz into an apartment to get into the building, wouldn't they be safer there than coming here where ICE would know that they would be hiding?
I think you're correct, and I'm sorry I keep saying this, but I
Okay.
think that would be another question for a Know Your Rights
Second
training.
question, is there a place where I can see what a warrant would look like that would be judicial so that I could show that to someone so they would know, and that'll come later too? Okay, thank you.
So if there are no further questions, I wanted to just close by saying a few words about executive orders generally, because I think there's a lot of confusion circulating about what these executive orders mean. And I don't want to underestimate the real impact that these executive orders have had on people, the chaos they've created, the fear they've created. But there are really excellent reasons not to just take these executive orders at face value and assume that they're binding and enforceable. So an executive order is a directive from the president telling the executive branch to take certain actions. So the president can tell a federal agency to implement a particular rule or emphasize a new policy priority. Executive orders cannot override the Constitution or federal statutes, and they cannot exceed the president's constitutional authority. So for instance, the Constitution gives Congress control over spending. The president cannot exercise spending power in an executive order. And I think it's also important to know executive orders can be challenged in a few different ways. Congress can enact a law reversing the executive order. A court can hold that the executive order is unlawful because it violates the Constitution or a federal statute. And then any future president can rescind previous executive orders. And then even if this falls kind of within the president's ability to direct federal agencies have to go through a rulemaking process under this federal law called the Administrative Procedure Act. And I know that sounds kind of boring, but it sets forth the process that agencies have to follow to make new rules. And those rules can be struck down by a court if they don't follow the Administrative Procedure Act. So there's process in place for how all of this should happen that the EOs are so far not engaging in, and there are reasons to think there are constitutional or federal statutory challenges to the executive orders. And as I'm sure you've seen in the press, we've already seen this in action. A court immediately blocked the birthright citizenship executive order as patently unconstitutional under the 14th Amendment. And recently, the National Immigrant Justice Center and the ACLU filed a lawsuit challenging the asylum executive order. This is the order that cites a purported invasion as a justification to deny asylum protections that are guaranteed by federal statute. And so there are a lot of reasons to think that these EOs are not enforceable the way they are drafted. And this will all play out in the courts over the coming weeks and months and years. State attorneys general also work together to challenge a lot of these laws. And so I think it's scary right now, but there are ways to challenge this, I guess is the main thing I want to convey. There are things we can do to fight back. Thank you so much.
Jillian, the associate pastor, and I were texting, and we were afraid that you were going to get asked why a loving God allows such pain and suffering to happen. That might have been even harder. Yeah, well, I defer to someone else too. That's great. Thank you, everyone, for coming. If you are looking for a Know Your Rights training, this is primarily for Lake Street folks, and there's a meeting after that will be completely members only. But if you show up here at the same place tomorrow at 3 p.m., there is also a Know Your Rights training, and I probably won't make you not come or keep you out. So if you wanted to ask those questions there, you probably could. It's tomorrow at 3 p.m. Thanks, everybody, for coming. I hope that you will meet each other and talk amongst yourselves also afterwards. And thank you so much for your presentation.